right, well, welcome everyone to the second meeting of the Adjudication Committee to consider a recommendation on public participation in agency adjudication. I'm Leah Robbins, an attorney advisor at ACUS, serving as staff counsel for this project. We are again joined by the project consultants, Michael San Ambrosio and Glenn Stashevsky, both from Michigan State University College of Law, and of course, our committee chair, Nadine Mancini. Before I turn it over to Nadine, I will do roll call. I will call two rolls. The first roll will be names of committee members and their alternates. After each name is called, please say here so that we know your mics are working. Nadine.
Here.
Jack Bierman. All right, hopefully he joins us soon. Claire Evans. Okay. Drew Vandenover, alternate for Adam Kress.
Yes.
Renee Landers. All right, Jeff Lubbers.
Here.
Thank you. Rick Thrasher. Roxanne Rothschild.
Here.
Thank you. Channing Strother.
I'm here.
Thank you, Channing.
Hi, Leah.
Russell Wheeler.
Here.
Thank you. Matt Weiner.
I'm here, thank you.
Thank you. All right, is there any committee member present whose name I did not call? Okay, so the second roll will be the names of ACUS members who are not on the committee and their alternates. Again, please just say here after your name is called to confirm your mic is working. I will not call the names of any members of the public who do not have speaking privileges. If any member of the public would like to speak, please indicate so by just writing in the chat. We'll start with the consultants. Michael San Ambrosio. Okay, he cannot speak. That's fine.
Here.
Okay. Oh, thank you. Glenn Stashevsky.
Here.
Awesome. Thank you. Doug Rowald, alternate for Dan Cohen.
I'm here.
Thank you. Wendy Blake, alternate for Helen Sarasia.
I'm here.
Thank you, Wendy. Jim Tozy. Now, is any ACUS member present whose name I did not call? All right. Well, Nadine, I will turn it over to you.
Great, thank you. Welcome, everyone. We're going to run through the ground rules as we do to make sure that everybody understands how to proceed. As Leah was mentioning, and we're going to decline that. Please note that only ACUS members, whether or not on the committee, and their designated alternates have full speaking privileges, meaning that a non-ACUS member should write in the chat if you would like to speak. To avoid background noise, please keep your microphone on mute and use the hand raise feature or add a comment in the chat feature if you would like to speak. I'll call on you. You can unmute yourself and then remute yourself when you're done. I'd also ask that ACUS members and their designated alternates use the webcam, please. With respect to attendees other than ACUS members and alternates, participation requires the unanimous consent of the committee members. And so time permitting, I will consider calling on such attendees at the appropriate points. And we will presume the committee members consent absent raising an objection. If any such participant would like to speak, please indicate in the chat feature or use the hand raise feature and then wait to speak until I call on you. You can unmute yourself and then remute yourself when you're done. For all participants, please use the chat feature only to indicate that you'd like to speak. Please do not hold any sidebar discussions in the chat or put substantive comments in the chat. Only members of the adjudication committee have a vote once we get to that point, which hopefully we will today. Please do not vote unless you're a member of the committee, and Leah and I both have a list of that if you're not sure of your status for voting. So I am looking forward to getting back into this. We made good progress at our last meeting, and I'm convinced we'll do the same for this meeting. So Leah, if you want to kick us off here with the great. Hopefully everybody can see. Great. So we're going to just start with the preamble, and we're just going to work our way through till the end of the document. And hopefully you've had a chance to review the draft ahead of our meeting. So we'll start with the first paragraph. If there's any comments, questions on the first paragraph, suggestions, looking for hands. Wonderful. Second paragraph, which takes us on to the next page. Oh, Russell, I moved too quick. Go ahead,
The last
Russell.
word, yeah, no problem. The last word on the page, there, I would make it those agencies. I didn't think the antecedent was really clear. I got confused on page one, page on line 15.
Line 15. I see, that's a good point.
It's a little longer, but I think I just stumbled over that and I wasn't sure who that referred to. I just make it those agencies, possessive.
Or just delete the word. I think it's clear if you just say participate in adjudications, not going to be other agencies' adjudications, presumably.
Any
Yeah, it works
preference?
too.
Yeah. We can leave it out and then. Committee on
I think leave it
Style
out, so that's a better solution.
Yeah. Great, thank you, Russell. We want clarity. We don't want there to be confusion. Anything further in this paragraph? So lines 13 to 20 on the screen. Next paragraph. 21 through 31. Okay, next one. 32 to 40. Apologies for my sirens. Okay, moving on. 41 to 49. Next one, 50 to 56. Leah, you got that? Great. Okay. 57 to 65. Russell, please.
I was unclear in line 65, what an important question of discretion is. that may mean something. It doesn't mean anything to me. Important question of law, policy, or discretion.
Hmm. Do the consultants have any thoughts there, or Leah?
I'm thinking that this probably came about because of the different categories of agency adjudication that we discuss, and one of them being what we call at some points discretionary determinations. And the example of that is like the decision to build a highway, kind of the Overton Park scenario. And so when deciding a novel or important question of law, policy, or discretion, I think that's what the term discretion is referring to. But I understand kind of outside of that context why it might seem a little confusing.
It's also, I'm
You're-
noticing too, we say discretion earlier in the sentence, right? So
Right.
we say,
Right.
yeah, in 64.
So this actually came from recommendation 2024-3, which uses this language,
Mm.
deciding a novel or important question of law, policy, or discretion. I think Glenn's examples are spot on, but that is where this language came from.
What if it just said or discretionary decision-making or something like that?
So provide agency heads with,
When deciding
okay.
a novel or important question of law, policy, or discretionary something or other.
Jeremy, welcome.
Hello. Sorry, I'm late. This is actually a term that's so as someone who worked on 2023-4, this is actually a term that appears in a number of agencies' regulations, referring to decisions that either as part of an appellate standard or a standard for presidential decision making, refers to novel or important questions of law, policy, or discretion. Really, it refers to things where like a policy statement will say, in the discretion of so and so, you can find X.
Mm.
So a good cause type determination sometimes falls under this.
I mean, if it's commonly used, I'm certainly going to withdraw any, well, it wasn't an objection, a comment, but I just, I wasn't aware of that.
Yeah,
Kind of a long-standing term. I mean, if we did some kind of like Westlaw search, we would find that it been used for probably before the APA, but I agree with Russell that it's meaningless to many, if not most people. So I would suggest something along the lines of what others have suggested to qualify it, or to discretionary something.
I think I'd keep it. We've used it before.
And just to clarify too, all this sentence or paragraph is really saying is what previous ACUS recommendations have said about public participation in agency adjudication. So, this isn't a quote necessarily, but I mean, that term is used all throughout 2024-3, and we are describing that past recommendation. So I don't know if that makes folks more comfortable with it or not, but
I think also, and my guess is this is meant to, these are kind of potentially overlapping terms, and it's meant to just kind of capture the field, of the decisions that agencies are charged with making.
Russell, any further thoughts?
Oh, no, I yield to the group. I'm with Matt that it's just a little,
Awkward?
yeah. Even if it is quite commonly used, but I mean, I'm not gonna fall on my sword over anything. It just, if everybody's happy with it, except the two of us, I don't see any reason to mess with it.
Glenn, did you have a further thought on it?
I don't have a strong view, but if we were to change it, maybe one possibility would be to say law, policy, or other discretionary determination, just because that connects to the ideas that precede it, and I think the different categories we've talked about. But I could also see the argument for keeping it the way it is based on things people have said. But I would choose between one of those two options, probably.
Thanks, Glenn.
Uh,
Any reaction to that possibility? Jeff?
This is not a very big issue, but the word other implies that it's, law, policy, or other discretionary determination. I don't think the questions of law and policy are discretionary determination. So I think the word other is kind of distracting there. And I don't see what's so difficult about talking about a question of discretion.
Question.
There are lots of questions of discretion that agencies have to deal with.
Yeah, I kind of agree with Jeff about the other word, and I think it is a question. They're specifically charged with certain questions of discretion. It's in an agency's discretion whether to do something. So I think it makes sense.
So I
Shall
favor
we-
the original language.
Yeah. Shall we leave it as is? I know Russell, you raised it. Matt had a thought as well, but
I'm happy to leave it as it is. That's the sense of the group. I was just raising it because I found it awkward.
anybody else? Okay. We'll move on to the last paragraph of the preamble. Okay, we'll go to the recommendation. First one. Jeff.
This is a very long sentence.
Indeed.
We've got a lot of clauses in it. And one thing that sort of got me begins with when appropriate. And then on line 75, we also have when doing so, et cetera, et cetera. So we've got these two whens. I thought maybe we could substitute, instead of when doing so, you could say opportunities for public participation in agency adjudications to allow, just shorten the sentence that way. I mean, you could also substitute something like in situations where doing so, that makes it longer. But it's just, I couldn't really come up with a way of turning it into two sentences too readily. But I guess my first suggestion would be to substitute to for the words when doing so would.
Thanks, Jeff. Any thoughts on that? Fewer words is always good in a very long sentence.
We need a comma or something after appropriate also.
So I will say that when appropriate, it's supposed to be when appropriate, considering the variations, considering the following. So I don't know.
We've got, it says when, and then unless.
Yeah.
I think Mr. Blake had a comment, or somebody else had a comment on this.
Oh, it's Wendy.
Wendy.
Yeah, sorry, for some reason, the hand raise function is not evident on our side of Zoom.
On React. It's in React.
I've looked everywhere, so, it is in React? Let me see.
React. It's in React.
Ah, yeah, we have a heart, so I didn't actually check that. Thank you for clarifying. I will now use the hand raise. One thought would be to end the sentence at adjudications and then something like this is particularly true. When doing so would allow members, I mean, it would break it up just a little bit. It's just a thought. But thank you for solving my hand raise issue. Appreciate it.
Yeah, let's try to, yeah, there you go.
I like that.
I like that too. I kind of like the emphasis in the first line, kind of just being not qualified, and then we can. Thank you.
Would it be possible to
React.
substitute the word in for when appropriate? In considering?
Does that change the meaning of the sentence? It seems like,
Yeah, Drew.
yeah, sorry, I'm just thinking through my thought, then.
Yeah.
It seems like the purposes of what determines whether something is appropriate or not in the way it was originally, but when we say in considering, it makes the purpose sort of the subject of what's going on. I'm not sure that makes sense. I might need to withdraw.
Wendy.
Yeah, I preferred when appropriate. So, when appropriate, considering all these things, agencies should provide. So I actually thought the clause was great,
Maybe.
gave a lot of flexibility and accounted for all the complexities in a succinct way. So I would leave it the way it was.
Does it need a comma then, which I think was
Yeah.
Russell's
I don't think so.
suggestion.
When appropriate, considering these things, comma, agencies should provide opportunities. I don't think it does, but I don't know if others have a different thought.
Roxanne.
Yeah, I apologize. I for some reason can't. Oh, now I finally got my hand up. Okay,
You got your hand up. Yeah.
So what if for this sentence we get rid of when appropriate at the beginning, put a capital C. So considering the variations in purpose, complexity, governing law, and degree of public interest in administrative adjudications, comma, agencies should provide opportunities for public participation in agency adjudications when appropriate to allow public. I mean, it's not that much shorter, but it just moves the when appropriate to in between adjudications and allow members of the public.
Thanks, Roxanne. Any thoughts on that? So now we're back to one long sentence, but it's a little shorter, a little more shorter than it was. Wendy.
Complicate. Oops, sorry.
I'm sorry, whoever was speaking, go ahead.
You sure? Oh, I don't just throw another idea into the mix. If you wanted two sentences, I put in the chat something like agencies should consider that list when providing opportunities for public participation. And then the second sentence should be that agencies should consider both the benefits kind of and the costs, really, which is what that second piece of the paragraph, I think, is asking agencies to weigh. It's a very rough draft, but
Yeah, I will just flag that then brings us into a should consider, and as a
no, we don't do that.
we try to be as direct as we can be. So like right now it says should provide. So you're against that backdrop, you're considering these variables in your adjudication, but we want you to provide, right?
Okay. Well, you could
I don't know. I just I guess
hear
it's
you.
yeah.
I mean, you could flip the sentence and say agencies should provide these opportunities, considering in light of, or
in light of. Yep. Wendy.
That might fix my concern. I was just concerned with the current edit by putting when appropriate to allow members, and that, to me, that makes it less conditional than the earlier version. So when when appropriate, considering all these things, agencies should provide public participation. To me, we should have an end stop. And then this is particularly true in these circumstances, but I want to make sure that we're not diluting or eliminating the point of every agency evaluating its relevant laws, the complexity of the issues, its process to, to ascertain whether additional opportunities should be included.
Leah, I think we did, I mean, this was language we added since the last meeting to try to account for some of the concerns that were raised in the first meeting. Glenn.
The different possibilities, I kind of like the original version with Wendy's proposed amendment, which I guess is what we have now, because I think it breaks it into 2 sentences, which is helpful, but it preserves kind of the original content.
Anybody else on this? Well, now we're back to breaking up the long sentence. Which maybe is.
The first sentence that way. I think you might say when appropriate in light of the purpose, complexity. I don't know, is that simpler? I don't know.
Let's try it. Let's try it. When appropriate in light of. Thank you, Judge. Likes the 2-sentence approach. Thank you. That's good. That's helpful. Any reaction to that? Word doesn't like it.
I like it a lot.
But don't let that stop us.
I think you could get rid of variations too, just say in light of the purpose, complexity, governing law.
So I think just why that language is there was based on the committee's prior discussion about emphasizing that when it is appropriate, considering the variations. So I don't know, I mean, that's up to the committee, but I believe the committee's intent was to kind of emphasize that. So I don't know how the committee
That's
feels.
my recollection as
yeah.
well. Wendy.
I still like when appropriate considering.
Okay.
Because you're asking the person to evaluate these various things, right? In assessing whether you should provide additional opportunities for public participation. But that's just, in light of, to me, it's not quite as precise as I guess the way I was reading it.
Okay. Anybody else?
I agree with Wendy.
Okay.
I agree.
All right. Thank you, Jeff, for kicking this off. It was a very long sentence. I think this is better. I do. Okay. If we're done with 1, let's go to 2. Wendy, do you have something on this? It's okay. It's totally fine. Okay. Making sure.
Got to lower my hand. Thank you, though.
That's totally fine. Just want to be sure everybody's heard. Let's move to 3 then. Okay. 4. Jeff.
A couple of things on this one. Well,
Yep.
first on the second line, 91, I think we have adjudication, twice there quickly. Could we just say resolution of routine claims instead of adjudication there, just to avoid that? And I guess I'm kind of jumping quickly, foreshadowing what I'm going to say about 5, but
That's all right.
I think we should try to be parallel with these 2 because 5, I think we should be able to start 5 with sort of when adjudications involve usually on complex novels. It's a novel issues of law, because it seems to me that 4 and 5 are trying to draw a distinction between these sort of routine claims and unusually complex or novel issues. That's really the difference between 4 and 5, it seems to me. So hopefully we can write them in a parallel way. But the only change I'm suggesting on 4 is just resolution instead of adjudication.
Michael proposes, what if we say, make important policy decisions involving routine claims or disputes? It's fewer words. Where's Jack Bierman? He would like fewer words. Was that what you were proposing, Michael? Yes.
That's another way of doing it.
A reaction to that? That's a good catch, Jeff. Anything further on 4 and then 5 is, Jeff, do you think that that's something we need to kind of sort language out for now, or something the Committee on Style could?
I think it's pretty easy to do. I think we just say when adjudications involve usually complex or novel issues of law, fact, or discretion, comma, agencies should develop,
Got it.
etc.
Thanks, Leah. Glenn?
Can we go back up to 4?
Mm-hmm.
I don't love the change from in the adjudication of to involving. I just feel like it reads strangely because it kind of sounds like the precedents or policy decisions are kind of involving routine claims or disputes, as opposed to, you're making establishing precedent or making policy decisions when you resolve these routine claims or disputes. So I think we should, but I like Jeff's suggestion of changing adjudication to resolution, to avoid the repetitious language.
Mm-hmm.
But I think the other change affects the substance in a way that is kind of confusing or problematic.
Okay.
I agree.
Yeah.
Okay.
That's-
Anybody else?
I just made a small point
Yes, please, Russell.
on line 101. Amicus briefs is plural, and then there's this singular word intervention. Or other interventions, something like that.
Let's try it.
But
Or other opportunities for?
Isn't intervention a term of art there?
Well, I don't know, is it?
I mean,
I
intervening.
think-
They're
I think it
intervening.
is.
They're actually intervening as parties, maybe.
Jeremy, please.
Yeah, how about mechanisms for amicus participation or intervention if you're looking for parallelism?
I don't know that amicus intervention makes sense as a phrase. If you're
No.
intervening
Like amicus participation or intervention.
Two separate concepts.
Oh, I thought amicus was modifying both.
Yeah, I mean, or you could flip it and say intervention or amicus participation to avoid that question.
Good point. That hit everybody the right way here. Thank you. Okay, we're going to move on to 6 with our list. Seven. Glenn?
Sorry, on number
Six.
6,
Too fast.
yeah. Michael and I had a suggestion for an additional kind of letter or option here in terms of mechanisms for public participation. So the change, if it were accepted, would be to add letter G. And I'm just looking for the language we came up with. Okay. It would be establishing pre-filing procedures that involve opportunities for public participation by interested stakeholders in appropriate circumstances. And this is a reference to really the example is FERC's pre-filing process for permit applications that we discuss in our report. It's a way of kind of having, it's sort of analogous to the rulemaking context when we talk about public participation before the publication of the NPRM, you know, sort of like very early public opportunities for public participation. And the way the FERC process works is basically that, you know, companies that are going to seek a permit to build a pipeline or whatnot, sort of notify the agency that they're going to do this. And there's a whole kind of pre-filing process where they engage with interested members of the public in the community where the project would be located, and the agency works with them on, you know, having public meetings and things of that nature, and, you know, sort of hearing from all of the interested stakeholders. And that all happens kind of before they even file the permit application. And the idea is that this will then streamline the decision-making process once the permit application is filed. And we found that this was like one of the more innovative things that we've heard about in terms of public participation in the adjudication context. And it seemed to work really well for FERC. And so, you know, we don't feel like this is anything that should be mandated or anything like that, but it is something that we feel like is worth considering for other agencies, particularly in the permitting and licensing context. And FERC has, like, this is all, you know, it's a whole pre-filing process that's set out. You know, they have procedural regulations. It's in the CFR, how this all works. And it seems like a pretty innovative and effective program. So that's kind of the idea. And if we added this letter G, I guess you'd have to move the and from E to F.
Any reaction to that? Wendy?
I had a question. Did you say that was prior to the application for the license being filed? Because the sentence starts out when adjudicating questions involving grants or denials of permission. So I'm just trying to get a sense temporally where the pre-filing piece goes.
Yeah, well, so it does, under the FERC process, the pre-filing does occur before kind of the formal permit application is filed. So, I mean, it's fair to ask, you know, whether how this fits with the kind of preambulatory language at the top of the paragraph. Let's see, when adjudicating.
I mean, is it something that you want to put in a separate paragraph since it really precedes the adjudication process?
I mean, I'd be fine with that if I was trying to, you know, we were trying to think of a way to add this concept, you know, that would be logistically simple. And so just adding it as one of these items kind of made sense. But, I mean, I could see having, you know, this be a separate paragraph that would say just something like agencies should consider establishing pre-filing procedures that involve opportunities for public participation by interest, you know, just as a standalone paragraph number 5.
Does it fit into 7? Does it fit into 7?
Yeah, I think it could be added into paragraph 7, maybe.
Say, for
it could-
example,
Yeah, or my initial thought was we could add sort of like a third sentence at the end saying agencies should also consider establishing pre-filing procedures. I mean, like, you know, that's just, I don't know if that's the best way of doing it, but that was what struck me off the top of my head. I think any of those 3 options would work. Wendy's probably right that sort of there's a little bit of tension between adding a letter G just because it kind of doesn't work great with that preliminary language. So putting it in either a separate paragraph or in paragraph 7 might work better.
would it help to highlight there the context in which you found that it would be most appropriate? So particularly, something like particularly in, I think you said
Well,
the licensing or permitting.
yeah, for sure. And I think that's why our original thought was to put it into that paragraph 6, because it's specifically in the you know, referring specifically to
Yeah, I see
grants or
that. Yeah.
denials of permission. That's why we originally put it into paragraph 6. I mean, and I guess another option would be like a new paragraph, you know, putting this idea above current paragraph 6, but then using that, but cabining it into the grants or denials of permission. So I think it would be something like when resolving or when considering grants or denials of permission, such as permit applications.
Agencies
should consider establishing pre-filing procedures. Yeah, I'm got too many papers in front of me. So I don't know. I mean, I guess I'm interested in kind of reactions to the concept, right? Is this something we want to encourage? And I really do think it is. Primarily because a lot of the public participation kind of best practices now recognize that earlier public participation is better. And there is some evidence to suggest that this concept or this idea can be brought into the permitting and licensing context in a way that can be really beneficial. And then, if people think that the concept is a good one, then, we have a few different options as to how to work it into the recommendation.
And you indicated that FERC is the agency where you saw it being used effectively?
Yeah.
Any reactions to creating a separate recommendation? Wendy, please.
I don't feel strongly about whether we create a separate recommendation or include it. I mean, I think the threshold question is, do we include the point or not? And then where? I, I'm fine including the point, but I wanted to go back on the proposed formulation. When considering grants or denials of permission, the such as permit application was confusing to me, right? Because when I'm thinking of the adjudicative process, the way at least we've envisioned it in the report, it's from the filing of the application, right, all the way through the permit decision to any post-administrative appeal processes for challenging the permit. So I think what I'm struggling with is from the when all the way through the permit application. So was this used in FERC prior to the submission of a licensing or permit application? Consider whether to use these pre-filing activities?
If I'm following the question, I mean, I think the way it works is that basically people who are going to apply for a permit give FERC a heads up. And I forget the exact terminology of the document that's filed, but it's basically like a notification that they're going to be filing a permit application. And that kicks in, it's a whole preliminary stage where there's a pre-filing process that involves a extensive public participation among all the interested stakeholders, the creation of like a stakeholder kind of mailing list so that all of the participants are kind of apprised of the different stages of the process and you know, kind of where things stand. And once the pre-filing process is completed and FERC kind of works with the potential applicant kind of throughout this process, you know, the goal is to kind of resolve concerns ahead of time and, you know, hear from everyone before the formal, you might say, permit application is actually filed. And then the idea is that, you know, by the time that the permit application is filed, all the interested stakeholders have weighed in and, you know, you know, some of the concerns and kind of preliminary problems or objections have been kind of ironed out so that the permit decision itself can go through more, you know, smoothly in a more streamlined way, because you've basically responded to people's objections kind of ahead of time.
I think my recommendation would be to just make it clear that by pre-filing procedures, we mean pre-filing prior to the application for a permit or license. So procedures that precede really what I view as the initiation of the adjudication. Once you file that application, it's really the start of it, and there's the permit decision. So
yeah, so maybe the way to put it would be something like agencies should consider establishing pre-filing procedures that involve opportunities for public participation by interested stakeholders in appropriate circumstances in advance of an application for a grant or denial of permission, such as permit applications. I mean, that's not particularly eloquent, but just sort of reverse, you know, kind of reversing the chronology of the sentence. So let's see, how does that? Agencies should consider establishing.
in advance of the filing of any application? I don't know.
Yeah, in advance of the filing of maybe applications for grants or denials of permissions, such as permit applications.
Any other reactions? My one concern would just be that this is not quite adjudication yet, which is the recommendation is all about the adjudication process, and this is kind of adjudication adjacent, like it's ahead of the actual adjudication.
Yeah, but I think the way that FERC kind of conceptualizes and runs the process, it really is all part of the same decision-making process. They're just, and part of the advantage of this, of the approach that they use, frankly, is that the permit applicant actually pays for a lot of the public participation efforts, kind of in advance of the filing of their permit application. So it also kind of saves the agency resources. But the idea is, you know, if you want to have a successful permit application where everything goes smoothly and we hear from all of the stakeholders and we resolve all the concerns in a way that everyone's happy with, the pre-filing process is an important kind of part of the entire, you know, decision-making process.
Should involve be create opportunities?
Maybe provide. The one other thing, as I don't know if, I think we need to convey the idea of inappropriate circumstances, but I feel like it kind of sticks out a little bit like a sore thumb in that space. I don't know how to agencies.
I mean, it could just be at the top as appropriate. Wendy?
I was gonna say that, just maybe to the beginning.
Yeah. Anybody else on this? Strong feelings about create or provide, or should we leave that to committee on style? You can just do provide, that's fine. I think that's typical language. And if we,
Could we move the inappropriate circumstances idea to the very end of the sentence? Would that? Because it's sort of like, I feel like they should consider doing it kind of all the time, but it'll only work in appropriate circumstances, kind of. So agencies should consider establishing pre-filing procedures that provide opportunity. Not sure.
I could see that getting changed at the plenary, but that's just me.
You mean the having the language at the end there, or?
Yeah,
Or-
that it would be at the top.
Oh,
So that
okay.
it frames
Yeah, well,
the entire concept.
okay. Well, then, I mean, I would
Maybe
certainly,
that's just, yeah.
no, I mean, I would trust your experience on that if you feel like that's going to be more widely acceptable that way, I would go that route.
Any other reactions to the language or the concept or any further discussion? Okay, we'll move on then to, I think we had, yeah, we can take that out there. Was there anything, I guess let's go just through 6 and 7 again. I'll just open the floor for 6 and 7 if there was any further thoughts there. Jeff,
I'm just wondering if this new paragraph maybe should,
excuse me.
since it is sort of the pre-adjudication process, maybe it should come before 4. I'm just occurred to me. I'm not sure I have a position on it, but since chronologically it's kind of pre-adjudication, maybe it should be the first thing under the methods heading. I don't know.
Right there.
I guess the argument against it is it's a pretty narrow specialized thing, but
Yeah. Any reaction to moving it? We've moved it, but you can see how it fits or flows.
I mean,
Yeah,
like,
Glenn?
I would trust your instincts on this with your experience, but to me, it actually makes more sense as it's more targeted, actually below 6. So it's chronologically before adjudication, but it's a subset of the things discussed in 6, which is both grants or denials of permission or non-adversarial discretionary matters. But again, it's just like subject versus chronology.
Glenn, did you have an additional thought here?
So just that, I don't know if I feel like Jeff was kind of right in thinking that because this is a more specialized thing, I would not sort of lead off with it. In some ways, I feel like the original 4 and 5 are kind of like the all-purpose recommendations, and then they get a little bit more specific and targeted as we go along. So I would have this one be either, right before 6 or, maybe right after 6, as Michael
Maybe it
is
should be
saying.
last.
Yeah, or even last, but well.
I mean, to the extent that we were looking at whether it fit in 7, it could just be after 7. Since it's such a narrow. Jeff, thoughts on that?
that gets me
Chronologically
back.
that doesn't work.
No,
But
I'm fine with that. I just think that maybe it's going back to sticking it into 6 because it is an opportunity for broader and more, and it's an innovative form of public engagement. So
what if we said in their adjudication process, looking at 115 here? I don't know
yeah,
if that gives it a little more,
that
and then make it part of.
mhm.
Mm-hmm. Yep. Go Leah, like that.
I think you could even take it as appropriate because the agencies are determining at the beginning.
Whether there are opportunities, yeah. Mm-hmm.
There's still a little overlap between the regarding important public projects and the application for grants, denials, or permissions. I don't know. Maybe that sentence should
Yeah, maybe it should,
come before the new
yeah.
sentence.
And then maybe we don't need the for example. It could just be in addition. I don't know. I don't know.
I think for example is better than in addition.
Okay.
I think it's an example. What does everybody think about that?
Yeah, Glenn.
Oh, sorry. I think that works pretty well. My one sort of caveat would be that the sentence, this enhanced forms of public participation may be most useful when adjudicating discretionary policy determinations regarding important public projects. That's more of the Overton Park scenario. And then the pre-filing procedures are more in the context of permitting and licensing. So the new sentence is not really an example of what comes before it. So I think going back to I think originally I had suggested we might just say as this new sentence that agencies should also consider establishing. And I would recommend going back into that direction because it's like an additional idea. But I do think it makes sense to put it in this paragraph because it's all like more innovative stuff.
Wendy?
Yeah, I mean, it fits. It's not a neat fit because, I mean, I see you're describing the adjudication process as really what precedes adjudication for the pre-filing. That really does precede filing of the application, which initiates the adjudication. I mean, I liked when we had agencies should also consider, as appropriate. Because this report isn't about what precedes the initiation of adjudication, I like the as appropriate language, but I'm not gonna fall on my sword on it. Because it does, I understand it's a really important point, but it doesn't, in my view, fit squarely within the confines of what the recommendation is about. So I would just recommend retaining it.
Okay. Anybody else?
I just want to raise the possibility again of making it its own paragraph. I don't know for again, I don't feel super strongly about this, but to me, it's like a very specific point that kind of could be its own paragraph, either just above or just before what I guess is 5. And I don't know, for me, I guess I keep coming back to the subject matter. Having both the public projects and then the file permits in the same paragraph, I don't know, it just seems a little awkward to me.
But they're both broader and more innovative forms of public engagement.
Yeah, I think that the 2 sentences before and 6 are more general. I don't know. So it feels to me, but again, I don't feel strongly about it, but it feels to me like it works best as kind of a standalone. But if you don't agree, don't worry.
Any other thoughts about placement?
Is there any downside to just making that last sentence the new paragraph 7?
I see Jeff's point that it kind of follows from the lead sentence there, but I guess you wouldn't need the also then, if it's a separate concept.
Yeah.
I just think it's it's good to have something like an
Framing it.
example or something concrete in
Mhm.
6, since 6 doesn't really
Mhm.
doesn't
Doesn't give you
specify
any
much.
specificity. Yep.
Yeah.
Mhm. I hear you.
I mean, what are these broader and more
Mhm,
innovative forms? What
mhm.
are these enhanced forms?
Yep. These
Yeah.
innovative. Yep.
Well, if you want to go that route, then I think the new material should be like a middle sentence.
Yeah,
In
I
other,
think we rejected that because the flow was a little off there.
hmm.
Any other concepts? I mean, I do think if we're in agreement to retain the concept, then and I think it fits at the end, perhaps as part of 6 or separate. I think that's really what we're wrestling with.
I mean, at least it kind of labels it as a broader and innovative form of public
Yeah,
engagement if
I
you put it
like
in
that
6.
framing. I agree with you, Jeff.
It kind of gives it more
Yeah.
sway, I think, in some ways.
Yeah, Leah, let's go back to that. She's
Yeah, I like
read
that. What
my
was the problem
mind.
about the middle? I don't remember. Why didn't we like the middle? I think that makes more sense.
With the for example. Wendy.
When we put the as appropriate in, because again, this is pre-adjudication. Agency should decide. Also, did we like drop a paragraph somewhere? Because this should be paragraph 7 right now that we're on.
Yeah, my numbering is all messed up
Okay.
right now, so
Okay.
I will fix it
Okay.
in post, but for now,
Okay.
I don't want to spend time.
No worries. I just want to make sure I didn't miss anything. Thanks.
You mean you can't keep up with all these changes, Leah? Like, move it there, move it there.
Well, I think committee and staff could smooth out whatever awkwardness we might be seeing here, but I think this might be closer to where the concept fits, if everybody's in agreement on that. Anybody else? Is everybody comfortable with that? Speak now. Okay, great. Let's go to communication and transparency. I know it says 6. I don't know if that's the right number. Yeah, we'll go with lines 123 through, that's a long one. All the way to the end of H. Jeff.
Just in terms of ordering these lettered
The
things,
letter. Yeah.
I think, who actually gets any information from public service announcements on radio and TV these days, So I think, I'm not saying take it out, but I think, why don't we put social media posts at least second? And, so I would, move social media posts second, email alerts third, and, at least do that. Now, some might say it's kind of formalistic to even have the Federal Register first, but I guess I don't object to that since that's kind of the traditional way of doing it. But I think we should, okay, so that's what I would do.
The Federal Register isn't first in the earlier list.
Yeah, I think we can all be traditionalists on the Federal Register, I suppose.
My point is, on the earlier list of mechanisms, Federal Register is in the, it's third.
Oh,
when I read what is now 8, is that it? My first thought was maybe this just is a reflection on my disconnectedness, that people don't rush to the Federal Register first thing in the morning. It's like Louis Brandeis, his idea of relaxation was reading reports of the Coal Commission, but most people aren't.
So Russell, you want to make it a TikTok?
My other, I had one other comment, and that is it necessary to explain even briefly why this list is so much longer than the earlier one? It's different nature, the proceedings are of a different nature and thus require greater outreach or something like that. I'm just asking the question.
So I will say, the previous one was meant to, let's see, discuss scenarios like methods where how agencies can get public participation when they're adjudicating cases.
But it's
Where,
only grants or denials or permission.
okay, of those cases. Whereas this one is really talking about how to kind of communicate that like publicize this information and alert potentially affected parties or those who are interested about it, about what's going on.
To the broader group of adjudication, right? Not just.
Right.
Well, might you want to say that in just a sentence? Again, I'm just raising the question.
Would you say it here, Russell, in this
Yeah,
paragraph?
yeah, and I'm not sure what even to say, but it just struck me as on first impression, this list is longer by 3 or 4 items, I think. How come?
Well, we could, if there's concern that the PSAs are not as effective, I mean, we say through means that are likely to reach them. I mean, I just don't know if we consider that to be a likely to reach. So maybe we could shorten the list. That was just my way of avoiding having to add more language. Jim, how are you? Welcome. Oh, you're muted, hon. I think you're muted still. Yep. Jim, we can't hear you.
Unmute. Now can you hear me?
Yes.
Okay. I just have a question. when I read this report, it was very informative. And there was a section in there that got my attention. And it said when you have these meetings that you're talking about in this paragraph, there's a tendency for groups to gang up and just send a very large number of people that support their position. And a lot of times that goes unchecked. So my question to the authors is there any place in these recommendations that you've addressed that statement that you made in your report that maybe the Fed should look at that stuff, they call all the people and no one else reads these things, and you get a very very one-sided group of people speaking. So my question is to the authors, have they addressed, that's what they said in their report, and I just wondered if any recommendations herein addresses that issue.
Yeah, I think that that concern is addressed in the preamble, and kind of a recognition that the appropriate level and forms of public participation are going to vary in different types of proceedings. And the language that's kind of sprinkled throughout the recommendations in terms of like as appropriate. I think there's sufficient, and this was a big focus of the committee meeting last time also, to make sure that it's clear that the agencies are supposed to, in any particular adjudicatory proceeding, think about what type of public participation makes the most sense
Yep.
Keeping in mind that they don't want to kind of bog down the proceedings and whatnot. So as I read this draft, I feel like that concern's been adequately addressed.
Good. Because pardon.
No, I just said thank you.
Thank you. That's all. This preamble would give a strong. When I read that, I should get that answer in my preamble, right? Okay. Thank you.
So that's how I read it.
All right. Thank you.
Back to 6, was there any other thought to language we could put here or shorten our list? If we took out the public service announcements, are we closer in number? Probably not. How many do we have? Yeah, January 6th.
Nadine,
Yeah.
I just wanted to say, I kind of reiterate what Leah was saying earlier. I think the two lists are addressing different things. The earlier list is like different ways of involving the public. And so
This is notification.
well, going back up to the previous list, yeah. So yeah, in paragraph 5, these are sort of different forms of public participation, right? So public forums, focus groups, issuing requests for information in the Federal Register. So that's these RFIs are like kind of a distinctive form of public participation where agencies, sort of publish requests for information. So this is just kind of short list of the different ways in which agencies can communicate with the public to get feedback. And the heading of that section is, if you go, yeah, there, methods for facilitating public participation, right? And then to go back to the paragraph we're discussing now, this is about communication and transparency. So it's like, how do we let the public know that we're doing this so that they can participate? And that's what this list is about. So we send out social media posts, we send out emails, we issue press releases. So I don't see any reason at all why the two lists should be like parallel with one another, because they're, two separate lists of different things.
Yeah.
I wasn't suggesting that at all.
Yeah, but I think if we leave out public service announcements on radio and TV, nobody's going to amend it to put it back in. So, I mean,
I agree with that parallel statement. I think if you just don't like a really long list, I think G, I guess the current G, could be a separate paragraph, because one is the methods of communication, the other is about working with partners to help distribute and publicize. And that is a very long part of the list, paragraph in the list, given the other
I'll
things.
just say that was added. It was originally a separate paragraph, but it was added at the last committee meeting, to whatever number this is right now, 6.
It was
so that-
moved.
8.
So that is something that was done at the last committee meeting, just FYI, because originally it was a separate paragraph.
Oh, okay. Yeah.
I think it's okay to leave it in. I mean, if we take it out, then we'll just have a longer list of number of recommendations. So
Wendy.
I think it fits here.
I was just gonna say, I think the list looks great, and I've lost track of what the concern is on this paragraph. So I just wanted to kind of come full circle and see what the remaining issue was. But I think it's fine. I mean, there could be 500 ways to do this, and all we're doing is providing a few examples.
Yeah, we haven't drop a bottle into the sea with a note, So,
Innovative
Barb,
and
we
potentially
we could add
helpful.
barber shops if you want. We have that.
well,
in
barber
Florida.
shops, yeah.
There's creativity.
Was there concern that I heard from Russell though about leading with Federal Register notices? Is that maybe something, I mean, obviously the audience knows that sometimes that's a good way, but it's gonna limit the people you reach, maybe. I think that was Russell's point. I don't want to put words in his mouth.
It just struck me as a little strange to open with that because most people, even those who are into this, would probably not turn there first.
Yeah.
And my
That's fair.
point was never that the list ought to be equally short or long. My only question is whether or not convince significantly conveyed to the reader why this effort needs to be somewhat a broader and more aggressive, and maybe the heading does it sufficiently. About the Federal Register, the only thing I noted in discussion with Jeff is that it doesn't lead off the earlier one.
Maybe we move it down, you know. Let's try it there.
We'll have to see what the Office of the Federal Register says about this. Our member from the Office of the Federal Register.
All right. Anything further on this list or this opening paragraph that intros the list? Okay, let's move to 146 to 148. '49 to 152. '53 to 156. Wendy,
Sorry, were you on, is that paragraph 10? The data collection?
not yet. Nope.
Yeah, sorry. Okay.
We're heading there next.
Lost track of the paragraphs. Okay.
That's fine. I don't think anybody else had anything on the prior section, so we can jump there.
Yeah, I wanted to suggest one addition to paragraph 12 that was in the last version. In the second sentence, we say agencies should collect feedback in a manner that complies with the Paperwork Reduction Act. And I wanted to add some text again that was in the last draft of the recommendation, which says, with the Paperwork Reduction Act and any other legal requirements or restrictions. I'm thinking of FACA. So let me pull it. Before we had subject to the Paperwork Reduction Act and any other legal restrictions. So I just want to get that concept in however you want to.
Jeff?
I don't think we usually don't say that agencies should do something in a manner that complies with the law. I mean, and I think people might read this as we're trying to strengthen compliance with the Paperwork Reduction Act, when that's not really our goal here. Our goal is to, make agencies or get agencies to collect more data, in conformance with the Paperwork Reduction Act or in compliance with, or you know, giving proper, attention to the Paperwork Reduction Act and other legal restrictions. So I don't really like this second sentence to read as a recommendation that says, you agencies out there, we think you're not complying with the Paperwork Reduction Act and you should do so. So I think we should try to make the focus of the Paperwork Reduction Act sort of secondary to in this sentence. And I don't have a exact language, but that it sort of bothers me the way it's written now.
Would you suggest just taking it out? And I think that's what Leah's suggesting here, which would be agencies should consider using.
I think it's important to have the concept. We can't just go ask
We
55.
can't ignore it. We shouldn't ignore it. No, I agree with
Okay.
that.
Yeah.
But in conformance with the Paperwork Reduction Act and other legal restrictions, agencies should.
So it would lead off.
Or you could put it at, maybe you could put it at the end.
It's at the end right now.
Yeah. In conformance with, or is that
In
too?
conformance with.
I like that better.
Anybody else on that?
We could also say consistent with the Paperwork Reduction Act and any other applicable legal requirements.
That's good too. Yeah.
Okay.
Thank you.
Anything else on what is now 10? And then on 11? Anything further on? I think that's the end, isn't it, Leah? Okay. Anything further on anything else before we see about voting? Leah, am I forgetting anything? No? Okay. Well, we'll put it to a vote. We can put a comment in the chat or we can just vote with a hand. Oh, Wendy, did you have something else?
Yeah, I just wanted to say thank you for all the revisions, Leah and the team, in light of the comments and feedback provided at the first meeting. I thought that the revised draft was great and I really appreciated you all accounting for the various bits of input that you received. So just wanted to say thank you.
Much appreciated.
Yeah, I want to second that. I think the reason we went through the preamble so fast was it was so well written.
Thanks, Leah, Jeremy, staff, consultants, everybody who pitched in. Okay, we'll go to a vote. So we can do a show of hands. If people want to raise their hands, indicate that they're good to go, or you can put a comment in the chat. Whatever works well for you, we'll count them all. So if everybody's in agreement, please indicate affirmatively. Yes, I see hands. That's great. I'm in agreement. I'm voting yes. Russell, thank you. Leah, anybody else we're missing? Matt is not there. I don't see Matt.
You,
Me, yes, yeah, I'll do my real hand.
I think Judge Thrasher could also vote. And I believe that's it.
Do we need to wait for them? Give them a minute. There, Judge Thacker. We are voting on the draft as revised. Are you in agreement with that? You can give us a thumbs up or a hand. A hand would be great. Thank you. All right. So we're just missing Matt. I think we're good to go. What do you think, Leah? Jeremy? Yeah. Okay, great. Thank you so much. And we got done early. Roxanne, thank you. Russell, Jeff, looking at everybody. Wendy, Drew, everybody, thank you so much. And our consultants. Fantastic.
Thank
Okay,
you.
so we don't need another meeting. And I look forward to seeing everybody at the June 12th plenary. We are back at GW, right? Which is great news. For at least for me, because it's so close. And I just want to thank everybody for everybody's participation, the fantastic feedback as usual. And I think we're in a good spot with this. So thank you so much for your assistance, and to the staff, Leah, everybody, fabulous work. So have a good afternoon.
Thank you. Bye-bye.
Yes, thank you
Thank
all.
you, everyone.